How does contract law address arbitration clauses? In today's fast-paced business world, understanding how contract law deals with arbitration clauses is more important than ever. With many companies opting for arbitration to resolve disputes, this topic is trending. You may be asking, how does this affect your business agreements? Let's break it down. Arbitration clauses are often included in business contracts. These clauses specify that, if a disagreement arises, the parties will resolve it through arbitration instead of going to court. The Federal Arbitration Act in the United States is the primary law that supports these clauses. This law makes arbitration agreements in contracts involving commerce enforceable, just like any other term in a contract. When a contract contains an arbitration clause and a dispute occurs, either party can request a court to pause any lawsuit and send the matter to arbitration. The Federal Arbitration Act outlines the rules for how arbitration should occur, including how arbitrators are selected and what documentation is required. Courts typically favor arbitration clauses and will enforce them unless there is a compelling reason not to. The scope of the Federal Arbitration Act is extensive. It applies to arbitration agreements in contracts related to maritime transactions and those involving interstate or foreign commerce. Consequently, most business contracts fall under its jurisdiction. Even if a contract is governed by state law, the arbitration clause must still comply with the Federal Arbitration Act's requirements to be valid. Arbitration clauses can be very detailed. For instance, some contracts may specify arbitration through organizations like the American Arbitration Association and outline where hearings will occur. They might also stipulate that each party bears its own costs, regardless of the outcome. Some clauses even prohibit class actions or group arbitrations, meaning each dispute is resolved individually. However, there are limitations. Courts do not have unlimited authority to review arbitration decisions. A recent Supreme Court case clarified that federal courts cannot use the nature of the underlying dispute to determine their authority to confirm or vacate an arbitration award. Unless there is diversity of citizenship, these cases usually go to state court. Internationally, arbitration clauses are also prevalent in business contracts. Courts sometimes face the challenge of deciding which arbitration clause applies when there are competing clauses in related contracts. For example, a recent ruling in the United Kingdom addressed how to interpret such clauses under English law. In summary, contract law treats arbitration clauses as binding agreements. The Federal Arbitration Act provides a framework for enforcement, and courts generally uphold these clauses. Businesses must pay close attention to the specifics of arbitration clauses in their contracts, as these terms can significantly impact how disputes are resolved.